Welcome back to the deep dive. Before we jump into today's material, I'd have a quick but really important request. If you get any value out of what we do here, taking these really dense, complicated legal texts and trying to make them make sense for your actual life,
Breaking it all down.
please hit that subscribe button right now. It is by far the best way to support the show. It tells the platforms we're doing something right, and it helps us keep doing this work.
It really does make a difference.
And while you're at it, maybe take a second to visit our website. We've got a full breakdown of all the statutes we're going to be talking about today, plus some visual aids that might actually help.
Which is interesting because you wouldn't think a legal deep dive would be a visual topic.
You wouldn't, but it kind of is today. It's about where we are allowed to be and how.
And how we're supposed to act when we're there.
Exactly. Today, we are tackling the Texas Penal Code, specifically Chapter 42.
No, I know that sounds incredibly dry.
Right. It sounds like the cure for insomnia. Penal Code Chapter 42. But let me reframe it for you.
Go ahead.
This is the how not to get arrested for being annoying deep dive.
Huh. That's a good way to put it.
Or maybe, where is the exact line between just being a jerk and actually being a criminal?
And that is pretty much the fundamental question that Chapter 42 sets out to answer. I mean, the official title is Disorderly Conduct and Related Offenses.
Right.
But if you zoom out and look at the philosophy behind it, this whole chapter is basically the social contract, just written down.
The unwritten rules made written.
Exactly. It's the state's best attempt to codify the rules of engagement for how to be a good neighbor in a public space.
We all kind of have that internal meter, You don't start screaming in a library.
You hope not.
You don't point a laser at a helicopter. But we're going to see today exactly where the law draws those lines. We're talking everything from foul language and stink bombs.
And yes, the law actually mentions stink bombs.
It does. All the way to riots, animal cruelty, and even flying drones over spaceports.
It's this fascinating mix of the old and the new. You have these statutes that feel like they're from the 1800s, talking about a breach of the peace. And they're sitting right next to brand new laws about, like, electronic harassment and putting tracking apps on someone's phone.
It shows how the law is constantly playing catch-up.
It's always stretching to cover the new ways that we as humans invent to bother each other.
So our mission today is to translate all of this. We're not just going to read the code at you. We're going to unpack the jargon.
Put it in plain English.
We want you to understand not just what is illegal, but why it's illegal. And maybe most importantly, what the actual consequences are.
Because some of this stuff isn't just a slap on the wrist. We're talking about felonies.
For sure. So let's start at the beginning, the foundation of the whole chapter. Section 42.01, disorderly conduct.
This is the big one. It's the catch-all for all the behaviors that society has just decided are too disruptive to tolerate in a shared space.
Okay, so let's start with the one that I think gets people confused all the time. Language.
Yes.
There's this myth, right, that you can be arrested just for, dropping an F-bomb in a public park. If a cop hears you swear, are you going to jail?
It is absolutely not that simple. I mean, the First Amendment still exists, even in Texas.
Right.
The statute says it's an offense if you use, and I'm quoting here, abusive, indecent, profane, or vulgar language in a public place. But, and this is the giant flashing neon sign of a but,
the legal nuance.
the critical nuance. It's only a crime if the language, by its very utterance, tends to incite an immediate breach of the peace.
Okay, that's the fighting words doctrine we hear about.
That is the exact legal term for it. Look, the law is not the morality police. It does not care if you're rude.
It cares if you're dangerous.
It cares if you're dangerous. If you're at the park and you stub your toe and, scream a profanity to the sky, yeah, that's vulgar, but it is not inciting violence.
No one's going to punch you for hurting your own foot.
No reasonable person is. No. It's not an invitation to a fight.
But who defines what fighting words are? Is it just subjective? Like, if I'm a really sensitive person and you call me an idiot and I decide to swing at you, did you just commit disorderly conduct?
That's where it gets a little tricky, but the standard is generally objective. It's what we call the average person's standard.
Yeah.
The question a judge or a jury will have to answer is this. Would an average person, hearing those specific words directed at them in that specific context, be provoked to violence?
So it's not about my personal feelings. It's about what a typical person would do.
Exactly. So if I walk up to someone on the street and scream a targeted, aggressive, maybe racial slur right in their face.
Okay, yeah, that's different.
That crosses the line. Almost certainly. That is a direct invitation to a brawl. The state has an interest in stopping that brawl before it even starts.
So the words themselves become the crime.
The speech itself becomes the criminal act because of what it invites.
Got it. Okay, let's look at another form of disruption in this section. Subsection A3. It is illegal to create, quote, by chemical means, a noxious and unreasonable odor in a public place.
Ah, the famous stink bomb clause.
I have to ask about the chemical means part. Does this law protect someone who just, has terrible hygiene or ate a really bad burrito before getting on the bus?
It actually does protect that person. The law is incredibly specific about chemical means for that exact reason, to avoid criminalizing natural bodily functions or someone who just, smells bad.
So this isn't about personal odor.
No. If you have a medical condition or you just have poor hygiene, you might be unpleasant to be around, but you are not a criminal. This statute is aimed squarely at the intentional release of substances.
Like actual stink bombs.
Like sulfur bombs, tear gas, pepper spray, things that are designed to clear a room or make a public space completely uninhabitable.
So again, it's not about being annoying. It's about denying the public the use of a shared space.
That's the core of it. If you force an entire movie theater to evacuate because you release some noxious gas, you have absolutely breached a peace.
Okay, let's pivot from smells to sounds. Noise. We have all dealt with this. The neighbor with the leaf blower at 6 in the morning.
Or the car with the subwoofer that's rattling your teeth.
Exactly. So where does the law draw the line? How loud is too loud?
So Section 42.01A5 makes it an offense to make unreasonable noise in a public place or near a private residence that you don't have a right to be in.
But unreasonable is such a vague word.
It is. So the law tries to give us a metric to work with. 85 decibels.
85 decibels. Can you contextualize that for us? What does that sound like? Is that a rock concert? Is it a whisper?
It's about the level of a gas lawnmower or heavy city traffic if you're standing on the sidewalk.
Okay, so it's loud, but it's not like ear-splittingly loud. A rock concert is way over that.
Oh, yeah. A concert can be over 100, 110 decibels easily.
Yeah.
But here's the really important procedural safeguard in the law. You generally can't be arrested for the noise immediately. The statute includes a presumption. It says the noise is presumed to be unreasonable only after a peace officer or a magistrate has ordered you to stop and you refuse.
So, practically speaking, you get a warning.
In almost every single case, yes. The goal here is compliance, not putting people in jail.
Right.
If the police show up at your party and say, hey, turn the music down, and you turn it down, the unreasonable nature of the conduct just kind of evaporates.
So the crime isn't just the volume.
It's often the defiance of the lawful order combined with the volume.
What about, say, a street performer? A busker? If I'm on a street corner playing a trumpet, that's easily going to be over 85 decibels.
Oh, for sure.
Can an officer just shut me down?
They can, yes. If you're near a private residence or otherwise interfering with public order. Now, a lot of cities have their own specific permitting processes for buskers that might create some exceptions.
But under state law.
Under the state law we're talking about, if an officer gives you a lawful order that it's too loud and you just keep playing, you are definitely risking a Class C misdemeanor ticket.
Okay, moving on to a very, very Texas topic. Firearms. We're an open carry state. We have constitutional carry. So how does a disorderly conduct law apply to guns?
This is a huge point of confusion for a lot of people. Section 42.01 really covers two different things: discharging a firearm and displaying one.
Discharging seems pretty straightforward.
It is. You can't shoot a gun in a public place. Full stop. Unless, of course, you're at a designated shooting range or you're acting in lawful self-defense.
But the displaying part, that's where all the nuance is.
That's where it gets complicated.
If I can legally carry a pistol on my hip in a holster, aren't I, by definition, displaying it?
You are displaying it, yes, but you are not violating Section 42.01. The law is very specific. It makes it an offense to display a firearm or other deadly weapon in a public place in a manner calculated to alarm.
Calculated to alarm. That sounds like it's about intent.
It implies both intent and the nature of the action itself. If a pistol is secured in a holster on your belt, the reasonable assumption is that you are simply carrying it lawfully.
Right.
But if you take it out of the holster and start waving it around, or if you walk into a grocery store holding a rifle at the, low ready position, scanning the aisles.
Yeah, that's a completely different message.
That behavior is calculated to frighten people. It is designed to alarm.
And that's true even if I don't actually point it at anybody.
Even if you don't point it at a specific person, Pointing it at someone is a much, much more serious crime.
Yeah.
That could be deadly conduct or even aggravated assault.
So this is a lower level.
Disorderly conduct here is just the act of displaying it in a scary way. It's the legal line between exercising a right and using that right to intimidate the public.
Got it. Okay, one last thing in this basic section. Indecent exposure.
Right.
The law talks about exposing private parts, but it uses the word reckless. Why is that word so important?
Because that word creates the legal buffer between a crime and, say, an accident, or a crime and a situation where you have a reasonable expectation of privacy.
Okay, what do you mean?
The law forbids exposing your anus or genitals in a public place if you are reckless about whether another person is present who will be offended or alarmed.
So let's run a scenario through that.
Okay.
Let's say I'm hiking way out in Big Bend, miles off any trail, and I'm totally alone, so I decide to, I don't know, change my shirt or relieve myself behind a bush.
Okay.
And another hiker just happens to come around the corner and sees me. Am I a criminal? Did I just commit indecent exposure?
Probably not. The question is, were you reckless? In legal terms, reckless means you were aware of a substantial and unjustifiable risk, and you consciously disregarded it.
Okay.
If you are miles from any marked trail in the middle of a desert, you probably didn't disregard a substantial risk. You reasonably assumed you were alone.
But compare that to 2.
Compare that to, say, urinating in a busy downtown alleyway on a Friday night. You know people are around. You are aware of the risk that someone will see you. That is reckless.
That makes sense. And then there's the other side of this, the peeping Tom part.
Right. The statute also makes it an offense to enter someone's property, to look into a dwelling, a hotel room, or even into a public restroom or changing room for a lewd or unlawful purpose.
So it protects the privacy we expect to have in those vulnerable moments.
Precisely.
Okay, so that really covers the individual acting mostly alone. But the law and the penalties, they change significantly when people get together in groups.
They do. This is where we move into things like riots.
Let's get into Section 2. When crowds go wrong, we really need to talk about riots.
And this is where the penalties start to escalate very quickly, and where the legal theory about who is responsible for what gets very interesting.
People throw around the word riot all the time.
I mean,
You know, it was a riot at the mall during the Black Friday sale. But in the Texas Penal Code, riot has a very specific mathematical definition. What's the magic number?
the magic number is 7. A riot under Texas law requires an assemblage of 7 or more people.
Why 7? That just seems so arbitrary. Why not 5? Why not 10?
It actually goes all the way back to English common law. Historically, I believe 3 people was considered a riot. Texas just raised the number to 7. The idea is that below a certain number, it's just considered a group fight or a public disturbance. But at 7, the thinking is you've reached a kind of critical mass. A mob mentality can take over.
And the danger to the public gets a lot bigger.
It increases exponentially, yes.
So you have 7 people gathered together. What do they have to actually do to make it a riot? It's not just a book club of 7 people.
No, of course not. Their conduct has to do one of a few things. It must create an immediate danger of damage to property or injury to persons.
Okay.
Or they have to be obstructing law enforcement or depriving people of their legal rights by using force or the threat of force.
Now, here's the part that I think is really scary. And I want you to explain this very clearly because the implications are just huge. Subsection F deals with liability. If I am part of a riot, but I'm not the one throwing rocks or breaking windows, am I still in trouble?
This is what's often called the guilt by association provision, and it is incredibly severe.
Okay.
It says that if you knowingly participate in a riot, you can be charged with an offense of the exact same classification as any offense committed by anyone else in that riot,
Whoa.
provided that the offense was, quote, in furtherance of the assembly's purpose.
Okay, walk me through that with an example. Let's say there are 10 of us. We're protesting, we're shouting at the police. I'm just holding a sign.
Okay.
The guy standing next to me picks up a brick and throws it, and it hits a police officer in the head. That's assault on a public servant, which is a serious felony.
A very serious felony.
I didn't throw the brick. I didn't tell him to throw the brick. I didn't even know he had a brick. Can I be charged with that same felony?
Potentially, yes. If a prosecutor can successfully argue that the purpose of the assembly was, say, to confront the police or cause disorder, and that the act of throwing the brick was in furtherance of that purpose, or was a crime that you should have reasonably anticipated might happen in that environment,
They're not on the hook?
You share the liability. Legally speaking, you own that brick just as much as he does.
That puts a massive, massive burden on an individual to basically police the entire group that they're with.
It absolutely does. And because it's so strict, the law does provide a kind of escape hatch. It's an affirmative defense to prosecution if you can prove two things.
What are they?
One, that the assembly was lawful when it started and you joined it. And two, that when one person engaged in illegal conduct, you retired from the assembly.
So the absolute moment that brick goes flying, I have to get out of there.
You have to leave immediately. If you stick around, the law basically says you are ratifying the conduct of the group. You're giving it your stamp of approval.
Wow. Okay. Let's talk about something related. Obstructing passageways. This connects directly to traffic and protests.
And specifically to a more recent phenomenon.
Right. We've seen this rise in what they call street takeovers or sideshows. Section 42.03 seems to have been updated specifically to deal with this.
It absolutely has. The legislature realized that the old language of just blocking a highway didn't quite capture the specific danger of, a bunch of cars doing donuts in an intersection while surrounded by hundreds of spectators.
The law gets so descriptive here. It talks about braking traction, spinning tires, steering the vehicle to cause it to rotate.
It sounds like they watched a few YouTube compilation videos and just wrote down exactly what they saw.
It really does. And they added a key detail, the audience requirement. It has to be in the presence of 2 or more persons assembled for the purpose of spectating.
And that's a really important distinction. And that's what separates an illegal sideshow from, say, a guy who just accidentally slides on an icy road in the winter.
Right. So what are the stakes for this? Is this just a traffic ticket?
No, not at all. A standard obstruction of a highway is a Class B misdemeanor. But a reckless driving exhibition is a Class A misdemeanor. That's up to a year in county jail.
And it can get worse.
It can get much worse. If the driver is intoxicated, or if anyone suffers bodily injury as a result, or if the driver has a prior conviction for this same offense.
Then what happened?
It becomes a state jail felony.
We should probably define that for people who aren't in Texas. What exactly does a state jail felony mean?
So in Texas, we have this specific tier of felony called state jail. The punishment range is from 180 days up to 2 years, served in a state jail facility.
And that's different from county jail.
It's very different. In county jail, you can often get good time credit, like 2 days credit for every 1 day served. In state jail, you often have to serve a day for day.
And you're a convicted felon.
Then you are a convicted felon. You lose your right to vote while incarcerated. You lose your right to own a firearm forever. And it stays on your record for the rest of your life.
There's also a specific part of this law that calls out emergency vehicles, right?
Yes, and this is critical. If you obstruct an authorized emergency vehicle, an ambulance, a fire truck, a police car that is actively operating its siren or emergency lights,
It's not a misdemeanor.
it is immediately a state jail felony. The law takes that incredibly seriously. If someone dies because that ambulance couldn't get through the intersection you were blocking for your sideshow, the legal jeopardy you're in is catastrophic.
But we have to balance this again with the First Amendment. Protests and marches, by their very nature, often block sidewalks or streets.
They do.
So can the police just roll up and start arresting everyone immediately for obstruction?
No, and Section 42.04 is the legal safety valve that prevents that. It essentially says that if the obstruction or the noise is a form of legally protected speech, like a protest or a political rally, the police must give a lawful order for the people to move or disperse before they can make any arrests.
So they have to ask nicely first.
Well, they have to give a clear, lawful order. Something like, you are unlawfully obstructing the roadway. You must move to the sidewalk immediately.
And if you obey that order...
If you comply, then no crime has been committed under this section. The arrest is only authorized for those who disobey the order. This is designed to prevent the state from using a simple obstruction law to silence unpopular speech without giving people a chance to correct their behavior.
That makes sense. Okay, let's move into our third section, disruption and false alarms. This covers things like disrupting meetings, but also some very specific and dangerous kinds of hoaxes.
Right. This whole section is really about protecting the integrity of our public processes and our emergency response systems.
Let's start with disrupting meetings, section 42.05. We all kind of know you can't just run into a city council meeting and start screaming. But how has this law adapted to the digital age?
This is the Zoom momming update to the law. During the pandemic, so many public meetings went virtual, and of course the disruptors followed them online. The law now explicitly includes electronic disturbance, including the hacking of any virtual component of the meeting.
So logging into a public school board Zoom meeting and, I don't know, blasting pornographic audio.
Is now the exact same legal offense as standing up and doing it in person in the auditorium.
And what is that offense?
It's a Class B misdemeanor.
There's also a very, very specific statute in here about funerals. Section 42.055. This feels like it was written in direct response to a specific group.
It almost certainly was. It's a direct response to the Westboro Baptist Church protests that were happening at military funerals a number of years ago.
All right.
The Supreme Court has affirmed that you have a right to protest, even in ways that are deeply offensive. But the court also said the state has a compelling interest in protecting the privacy and sanctity of a funeral for grieving families.
So Texas created a buffer zone.
A literal buffer zone, yes.
What are the dimensions of that zone? How far away do you have to be?
You are prohibited from engaging in picketing within 1,000 feet of a cemetery, mortuary, or church where a funeral is being held.
1,000 feet. That's a pretty significant distance. That's more than 3 football fields.
It is. And there's a time element, too. That ban is in effect from 3 hours before the service is scheduled to begin until 3 hours after it concludes.
So it effectively pushes any protest completely out of sight and out of earshot of the mourners.
Which is exactly the intent. It's an attempt to balance the free speech rights of the protesters with the right to privacy for the family.
Okay, now let's talk about false alarms, and specifically Section 42.0601, which covers swatting.
A very dangerous and malicious act.
For anyone who doesn't know, can you explain what swatting is and why the law has to treat it so harshly?
Swatting is when someone maliciously calls 911 and reports a fake but incredibly critical incident, usually something like a murder in progress, a hostage situation, or an active bomb threat at a specific address.
And the goal?
The goal is to trick the police into sending their heavily armed tactical team, the SWAT team, to kick down the door of an unsuspecting and innocent victim.
We see this happen a lot to online streamers or rivals in video games.
Exactly. It is literally using the police force as a weapon against someone you don't like. And it is so incredibly dangerous. You have officers arriving on scene believing they're walking into a lethal ambush.
The statute here seems to create a ladder of penalties based on what happens as a result of the fake call.
It does. The base offense for making that false report is a Class A misdemeanor, which is already serious. But if the emergency response results in serious bodily injury or death to any person,
To anyone at all.
anyone, the victim, an officer, a bystander, then it becomes a third-degree felony.
Let's unpack that. If I make a prank swatting call and the tactical team raids your house, and in the chaos and confusion, they accidentally shoot and kill you, an innocent person, I am held responsible for your death.
Legally, yes. You are the one who set that fatal chain of events in motion. A third-degree felony in Texas carries a punishment of 2 to 10 years in prison.
Wow.
The law recognizes that by making that call, you created a deadly situation and you have to be held accountable for the consequences.
Included in this area of the law is also interference with 911. This isn't about making fake calls, but about stopping real ones from going through.
Yes, Section 42.062. And this is critically important in, for example, domestic violence cases. So often, when an assault is in progress, the victim's first instinct is to grab a phone to call for help.
And the abuser's first instinct is to stop them.
They grab the phone and hang it up, or they smash it against the wall. That act of knowingly preventing or interfering with someone's ability to call for emergency assistance is a separate and distinct crime.
And what's the penalty for that?
It's a Class A misdemeanor. And if the actor has a previous conviction for the same thing, it becomes a state jail felony. The state is sending a very clear message that lifeline to 911 is sacrosanct. You do not get to cut it.
That makes perfect sense. Okay, let's move into our fourth big section, harassment in the digital age. This is an area where I feel like a lot of people might accidentally cross legal lines or where they feel helpless when they're the ones being targeted.
For sure. So the main statute is Section 42.07, harassment, and it's broad. It covers communications by phone, text, email, social media, you name it.
It lists a lot of different prohibited behaviors, making obscene proposals, threatening bodily injury, making a false report of someone's death. But there's one in there that seems almost petty, but is still illegal.
Which one?
Failing to hang up.
It doesn't feel petty to the victim, I can promise you that. The statute forbids making a phone call and intentionally failing to hang up or disengage the connection.
Right.
Think about the old landline era, or even today on a cell phone. Someone calls you, says nothing, and just listens to you. Or they keep the line open so you can't make or receive other calls. It's a pure power play designed to torment and control.
Let's talk about the modern tech updates in this section. Tracking. I mean, Apple AirTags have been in the news constantly for this kind of abuse.
And the law has caught up. Subsection of the harassment statute now makes it a specific offense to knowingly install a tracking device or application on another person's motor vehicle or personal property without their effective consent.
Okay, what about my kids? Can I put an AirTag in my teenager's backpack to make sure they get to school? Okay.
Generally, yes. If they're a minor and you are their parent or legal guardian, you have the authority to consent on their behalf, but you absolutely cannot do it to your spouse without their knowledge and consent.
Even if you're married?
Even if you're married. And you certainly can't do it to an ex-girlfriend or an ex-boyfriend.
What if I'm just worried about their safety? You know, I just want to know she got home okay argument.
The law is black and white on this. It requires consent. If you slip a tracker into someone's purse or you magnetically attach one to the bumper of their car without them knowing, you are committing a crime. Your stated concern does not override their legal right to privacy.
Then we have doxing. That's section 42.074, unlawful disclosure of residence address or telephone number.
This is aimed directly at the weaponization of someone's personal data.
Right.
It makes it a crime to post someone's home address or phone number on a publicly accessible website with the intent to cause harm or threat of harm to that person or their family.
The intent is the key part of that.
It's everything. If I post a flyer online for my lost dog and has my neighbor's phone number on it because they're the one who found the dog, that's not doxing. There's no malicious intent. But if you post a police officer's home address on an anti-police forum with a caption that says, "This is the guy who arrested my friend, maybe someone should go pay him a visit,"
then the intent is clear.
The intent is obviously to incite harassment or harm. That is doxing, and it's a crime.
So how does stalking differ from harassment? Stalking has its own section, 42.072.
Stalking is a serious escalation. Harassment is designed to be annoying or embarrassing. Stalking is designed to be terrifying.
Okay.
Stalking requires a scheme or course of conduct, which means repeated actions directed at a specific person. But the real legal threshold is the victim's reaction.
The fear factor.
The fear factor, exactly. The conduct must cause the victim to feel terrified, intimidated, or afraid of bodily injury or death.
And there's another part to it, right?
Yes. And here's our old friend, the reasonable person standard again. It must be conduct that would cause a reasonable person in the victim's shoes to feel that way.
So let me try a silly example. Let's say I have a deep irrational phobia of the color yellow.
Okay.
And you find this out, and you start wearing a yellow shirt and walking past my house every day for a week. And I am genuinely terrified. Is that stalking?
That's a great question, and probably not. A reasonable person is not terrified of a yellow shirt. The law doesn't criminalize you for accidentally triggering someone's very specific, irrational idiosyncrasies.
But what if you knew about the phobia?
Now, if you knew about my deep phobia of yellow and you were intentionally exploiting it to cause me terror, a creative prosecutor might try to make that case. But generally, stalking refers to things like following someone, showing up at their work uninvited, sending threatening gifts, things that any objective person would agree signal danger.
There's one more very specific protection in this section that I want to touch on. It's for shelters.
Yes, section 42.075. This is specifically to protect family violence shelters and shelters for victims of human trafficking.
Right.
These places rely on secrecy and anonymity to keep their residents alive. It is a specific offense to disclose the location or even the physical layout of one of these shelters if your intent is to threaten the safety of the people inside.
So you're blowing the cover of a safe house.
And the law treats that as the serious and dangerous act that it is.
Okay, we're now heading into section 5, protecting the vulnerable. And this section covers two groups: animals, and interestingly enough, corpses.
It makes sense in a way. Both are categories of victims that cannot speak for themselves or defend themselves from abuse.
Let's start with animals. The code makes a clear distinction. It splits them into livestock and non-livestock. Why do that?
It's a very Texas distinction. Texas is a huge agricultural state. Livestock, cows, horses, sheep, poultry are seen as both animals and, frankly, as property and livelihood.
Whereas non-livestock.
Non-livestock, your dogs, your cats, are seen primarily as companions. The laws protecting them are slightly different in the details, though the core concept of preventing cruelty is the same.
For livestock, under section 42.09, it mentions something very specific: tripping a horse. What is that about?
That targets a specific practice often found in certain charita or Mexican-style rodeo events where a horse is deliberately tripped by roping its front legs to make it fall dramatically.
And Texas outlawed that.
Yes. The law says you cannot use a wire, a pole, a rope, or any other object to intentionally cause a horse to fall or lose its balance for entertainment or sport.
Then for pets, the non-livestock, under 42.092, we see the standard cruelty provisions. Torture, killing an animal without the owner's consent, but also failure to provide.
And this is where simple neglect becomes a criminal act. If you own an animal, you have a legal duty of care.
Okay.
You must provide necessary food, water, care, and shelter. Leaving a dog chained up in the backyard during a Texas summer with no shade and no water isn't just being a bad pet owner, it's a crime.
What about assistance animals, like guide dogs?
They get their own special section, 42.091. This provides a higher level of protection for guide dogs, service animals, that sort of thing. It's an offense to attack, injure, or kill an assistance animal.
That makes sense.
But here's the crucial warning for other pet owners. It is also an offense if you permit your own animal to attack an assistance animal.
So if I know my dog is aggressive, and I let him off leash at the park, and he runs over and attacks a blind person's guide dog, I'm the one who's legally liable.
You are. You failed in your duty to control your animal, and as a result, you damaged what is essentially a critical piece of medical equipment for a person with a disability.
Let's talk about the organized cruelty, dogfighting and cockfighting. Obviously, making the animals fight is illegal, but the law goes further. It goes after the spectators.
It has to. The entire illegal industry of animal fighting is fueled by the spectators and the gambling that they do. So sections 42.0 and 42.105 make it a specific offense to knowingly attend a fight as a spectator.
So the old, I was just watching, I didn't do anything, excuse doesn't work.
It does not work. If you are there, you are considered part of the criminal enterprise. And if you are convicted of any of these animal cruelty offenses, there's a really interesting and stinging penalty in section 42.107. It's called the possession ban.
You lose your right to own a pet.
For a period of 5 years following your conviction, you are banned from owning, possessing, or having custody of any animal. If you get convicted for abusing a dog, you don't get to just go out and buy a cat the next week.
Wow. Okay, moving to the end of this section. Abuse of a corpse. Section 42.08.
Yes, this statute forbids treating a human corpse in an offensive manner.
How does that include?
It includes things like disinterring, which means digging up a body damaging a corpse or vandalizing a grave. It also covers the trafficking of human remains, like buying or selling bodies or body parts.
That phrase offensive manner seems really broad.
It is intended to be broad. It's a law that has to rely on our shared community standards of decency and respect for the dead.
Okay, we are into our final section, section 6, modern hazards. And this is a very eclectic mix. We've got lasers, drones, and flags.
A very strange mix to finish on, yes.
Let's start with lasers. Section 42.13. We've all seen those videos online of some idiot pointing a green laser at a police helicopter.
And it is so much more dangerous than people realize. The beam from even a small handheld laser, when it hits the plexiglass bubble of a cockpit, it refracts and can fill the entire cockpit with a blinding green light.
That can blind the pilot.
It can temporarily or even permanently blind the pilot. So the law specifically targets pointing a laser at a uniformed safety officer.
That includes
Police, firefighters, EMTs, even private security officers. It's a crime to knowingly direct that light at them while they're on duty. And if you actually cause bodily injury, like you damage an officer's retina, it jumps from a misdemeanor to a third-degree felony.
Okay, let's talk drones. Section 42.15, we all know you can't fly them over airports. But the Texas law recently added spaceports.
This is, for all intents and purposes, the Elon Musk provision. With SpaceX down in Boca Chica and Blue Origin out in West Texas, the state now has critical space launch infrastructure to protect.
How does the law even define a spaceport?
It's defined as a launch or landing site for spacecraft that is designated as such by the FAA. The law makes it an offense to operate an unmanned aircraft over one of these facilities, or to allow your drone to make contact with the facility or interfere with its operations.
It makes perfect sense. You don't want someone's $500 DJI drone crashing into a $1 billion rocket on the launch pad.
Exactly. It creates a necessary no-fly zone to protect the technology and, more importantly, the safety of the launch and landing operations.
All right, last one on the list, the flag, section 42.11, destruction of flag.
This is, without a doubt, the most constitutionally tense and complicated section we've discussed all day.
The Texas law says it is illegal to intentionally damage, deface, mutilate, or burn the United States flag or the Texas state flag.
That's what it says on the books, yes.
So wait a minute. Texas v. Johnson, the landmark Supreme Court case. Didn't that rule that burning the flag is a form of protected free speech?
It did. In 1989, in a case that originated right here in Texas from a protest in Dallas, the Supreme Court said that the government cannot prohibit an expression of an idea simply because society finds the idea itself offensive or disagreeable.
So is this Texas law invalid then? Is it unconstitutional?
As applied to a political protest, effectively, yes, but it stays on the books. It creates this very weird legal situation where the statute exists, but enforcing it against a protester would almost certainly be found to violate the Constitution.
But there is a carve-out in the law.
There is. It provides an exception for the proper disposal of a damaged flag.
Right, because the official, respectful way to retire an old, tattered American flag is, in fact, to burn it ceremonially.
Correct. So the act of burning itself isn't the crime under the statute. The intent to offend or desecrate is what the law tries to criminalize.
But the Supreme Court said that intent to offend, when it's political speech, is protected.
And that's the conflict. So for all practical purposes, this section of the law is largely symbolic at this point.
We have covered a massive amount of ground today. I mean, from fighting words all the way to spaceports.
It's a lot to take in.
So if we take a step back and we look at Chapter 42 as one big, coherent idea, what's the real takeaway? What's the big picture?
The big picture, I think, is one word: boundaries. Every single law we just discussed is about creating a boundary between your rights and your neighbor's right to peace and safety.
That's a great way to put it.
You have a right to free speech, but that right ends at the boundary of inciting a riot. You have a right to own a firearm, but that right ends at the boundary of terrifying everyone in the grocery store.
You have a right to fly a drone.
But not over a rocket that's about to launch into orbit. It's all about respecting the boundaries that allow us to live together in a society.
And it really hammers home that reasonable person standard we kept coming back to over and over.
It absolutely does. The law can't possibly write a specific rule for every single scenario that could ever happen in the universe, so it has to rely on us. It relies on the collective common sense of society. It's constantly asking the question, would a reasonable person, a reasonable neighbor, do this? And if the answer to that question is no, you are probably on the wrong side of Chapter 42.
That is the perfect takeaway. Be a reasonable neighbor. Don't be the person that forces the legislature to write a new law about you.
Please, don't be the reason we have to have a law about, I don't know, no juggling chainsaws near a petting zoo. Just be reasonable.
Thank you so much for listening to this deep dive. If you found this helpful, or if it just maybe scared you straight a little bit, please share it with a friend. Maybe that friend who owns a really powerful laser pointer.
Good idea.
And don't forget to subscribe and check out our website for the full text of all these laws we talked about. We will see you on the next one. Stay safe out there.